Discussion. I'll be discussing to you with the two major topic. One is ceiling of land holding and the other one is with the surrender of land. I'll be just discussing to you with what are the procedures in respect of ceiling and how and when the surrender can be made. Question, that is, both these two topics are equally important from the point of examination. See, as soon as we come across understanding with the Land Reforms Act 1961, one of the major reason as why this enactment was so attracted is because of this ceiling limit, which said that is any person, it could be whether a landlord or a tenant for that matter, if he happens to own certain land, if he happens to possess certain land, then such possession of what is holding with or any land which a person happens to hold by way of tenant or in other form of interest, then such person can only hold the land subject to the limitation of the size in which he is holding with. And this is one such also the objectives of the Land Reforms Act. So that being the case, it is necessary for us to understand as what is this ceiling and how and what extent is ceiling that a person can hold a land in his favor. And more particularly under 2 class 12 we were discussing to with the family, it is equally required to be understood with. And when I say with the ceiling speaks with the individual, ceiling limit speaks with the family, and also ceiling limit speaks with the joint family business, joint family concern. And section 63 to 66 speaks with the ceiling of land holdings. To what extent you can hold the land. Says under section 63 it says that is every person who is the member of a family, or where a case if he has no family, then that individual for that matter, except as that is provided under the Act, is entitled to hold the property, that is the agricultural land, as a landowner or as a landlord or as a tenant or as a mortgagee with in his possession or in his possession or otherwise has under the capacity, maybe suppose if sometimes it might be given to other person with my supervision. So that's why it says in any other capacity, if he happens to hold a land, then that land what is holding shall not exceed more than the ceiling area. And what is the ceiling area? See, when it comes to the ceiling area is concerned, ceiling area of a person who is not a member of a family, that is, who is not a member of a family, and then if it is an individual, then it is 10 units. 10 units. 10 units. To an extent of 10 units, he can hold the property. That is, I again repeat, a person, that is ceiling area of a person who is not a member of a family or who has no family, then he can hold the property to an extent of 10 units, provided that where if the family consists of more than 5 members, then plus addition to this of 10 units, for every additional extent of 2 units shall be given to every 5 members, that is every member not excessing or not exceeding of 5 in nature. So it is something like this, the calculation goes like this. If I am an individual having no family, then it is 10 units. But if I have a family which is not exceeding more than 5 in number, then again this is the 10 units. If I say, if myself, and especially in cities we can come across with V2 and for we both and for us V2. It is that, it is something like this. Or every family with 2 kids, 4 members. So even it is 4 members, it is 10 in number. But where if the family consists of 4 more than 5, so the maximum limit here under this for a family is concerned, it is 5. if any person exceeds more than 5, suppose say 6 or 7 or whatever it is, for each individual it is 2 units. For each individual it is 2 units, which such units should not exceed more than 5 members. In a way I can say that is calculating 2 to 2, because each member, that is if there are 5, 2 to 2, 10 units come. So when I calculate with as a family more than, suppose if there are 12 in number in the family, then it is only, what is that? To an extent of 5 members, 2 per unit is being given. So when I say to the extent of 5 members 2, it comes to 10 units. So this 10 units what I have can be added to this. So 10 plus 10 is equal to 20 units. To an extent of 20 units of the land I can go for enjoying with. So that is my ceiling limit. In a nutshell, if I am to speak upon with this, I can say like this, my friends. That is, for each individual or for a family of less than 5 in number, then for them it is 10 units. To an extent of 10 units of the land they can enjoy with. Where if the family consists of more than 5 in number and less than, what is that, 10 in number, then for each person, a part of those 10 units, for each person 2 units. If there are 6, 2 plus 2 plus 2. But in total, it should not exceed more than 20, because the maximum 5 persons have been taken in consideration to ascertain the ceiling limit. So as an aggregate they take, and it shall take 20 units shall be the units that what a person can maximum hold in his property. By virtue of the amendment that is brought down to this section 63 under 2 capital A, the ceiling area of a tenant, for that matter, that is under section 5 class 2B, it says that is it should not exceed more than, that is if you are coming for a tenant coming under the class of 5 2B, then it should not exceed more than 40 units. That is how we see 5 2 here speaks with, that is the property which has in Uttara Kannada, Dakshina Kannada, where if a person is registered as an occupant and where that land is used for an aquaculture purpose, or a period which is, or if a property is being leased for a period of not more than 20 years of time, and that is been registered by DC, then they go for 40 units. Otherwise, this is the fixation that how we go with the ceiling unit. And what all this includes with to this ceiling limit. This is how we go. I am repeating this. It is 20 units. Mind this. See, in Karnataka, we see this, that when we calculate the ceiling limits, as we see, the ceiling limit of every individual shall not be exceeding more than 10 acres to 54 acres of land. In Karnataka we see, generally we see this, that the land what a person holds will not be exceeding more than the 10 acres to 54 acres of land, depending upon the number of persons and other variations. But the land where it is being used for stud farming or cultivation of linear projects, or where the same land is used for the purpose of coffee board, then they are exempted from that of the ceiling limit. And also we see today, if the property is used for religious institution or for the charitable purpose, to the extent we shall see that they are exempted from this ceiling limit. But otherwise than this, we shall see that all those ceiling limits are equally applied therein. And overall, what all the property comes under this ceiling limit. That is, in case of a family, as I then said to you, the ceiling area is applied in aggregate to that of the land what the members are holding as a family member, which they are entitled to. Suppose, say, if I am a brother, if I am a member of this family and I am residing for some reason, I am residing in other part of the city, where if I also happen to hold a land there, then the aggregate of those land is taken and put in together, we shall say that what would be the land which has been holding, which should not exceed more than this area. This is one criteria. Where if the same in a family, if any female has derived the property by way of stridana, then such land shall also be taken in aggregate of the land what the family is going to hold the property in the form of Stridhana property. That is, there even Stridhana property is brought into the ambit of family, and that would be considered as the property of the family, and it is subject to that of the ceiling limit. Whereas when it comes to the joint family property, where a person is not a member of the family but is a member of the joint family property, then such land, that is a member of such family who is also a member of joint family, then the share of such member in the family shall be taken in while calculating the land of which they are holding with. So it is taken in aggregate. That is, when I am holding the land, suppose say if I have come outside, I am also equally a member of joint family, but I am not staying with the joint family. Then what would be the aggregate property of the joint family? Suppose if I am going to get 1 unit of land, 2 units of land there, then I can take that 1 unit of land to my account, and the ceiling limit is going to be calculated in that regard. So it shall say that on the aggregate of what the land has been considered, which the land is held by him separately for the purpose of him, and the held land which is held as a part of his share would be equally taken into in consideration, and on the basis of that the land is going to be made or assessed. It is going to be assessed with the limit, whether it falls under the ceiling limit or not. Where if the same were to be a private trust, suppose if the landowner is holding the land under the private trust, then in whose hand the ceiling is to be counted with, is to be looked with. Suppose if the land what has been held under a private trust is a revocable trust, that is at the wish of the author of the trust, then the land shall be held in the name of the author himself or the successor or his interestee, such person. So in calculating the ceiling limit, we look at the author or the successor or that of any person who claims an interest through this successor. We take the calculation, and ceiling limit is looked at the interest of these persons. Calculated, it will be calculated. Where in other cases, not of an author, it is revocable in the terms of author. But if in all other cases, if such lands are being deemed to be held for the beneficiaries, then the land is to be calculated in the heads of the beneficiaries. The proportion of the amount in the respective interest in such trust has to be calculated, and the income derived from out of that shall be considered to be the income of the beneficiaries. Whether it is held in a private and partly public, whatever it is, this section shall be applicable ratably in accordance with that of the private trust is concerned, because public trusts are exempted. So in that way I am speaking with. So rateability is being going to taken into consideration, or it will be taken to a consideration in assessing the ceiling limit. Suppose say in other case, where if a person is cultivating to the extent of land in person and who is not a member of the family, but he has certain shares in that of the family as a member of the land, or if the person who happened to be a part of it under the cooperative farming, then that would be taken into an account as what shall be the interest of him in that of the cooperative farming sector. That is, if a person happens to hold a property which he has given it for a cooperative farming, and what is his ratio that is holding in that of a cooperative farming is also considered to that of the ceiling limit. So in a way I can say you, my friends, there is no escape. That is, a person, on whatever the no more he is holding the property, it is being brought into the ambit of ceiling limits of an individual. There is no escape of a person. And if the same were to be an educational institution, of course today there is also a religious and charitable institution, so some exemption is being given. Society, trust, or if the trust is of a public nature more particularly, then they are capable of holding. And if the same were to be held by these persons solely as an institution, then my friends, the ceiling limit for this kind of groups is 20 units. That is, they can hold up to the extent of 20 units. So in determination of all those things, especially a limit with that of the society, trust or institution, what shall be the ceiling area, how much of the land that they are holding is determined by the authority, and the decision of the authority, that is prescribed authority, shall be final in this regard. And it says that whatever the exceeding area of that which you are holding a land shall deem to be a surplus land, that is in the, whether it is in the name of the institution, society or trust, and that shall be surrendered to the government, state government, in respect of whatever the surplus land you are holding. This is in case of society, trust. Of course, in case of educational institution or so and so, we shall say that it is 20 units is the maximum, subject to the provisions that the state government can extend of this units also. Now, when it comes to the sugar factory, more particularly, my friends, if a sugar factory is happening to hold any land, except where it is solely used for the purpose of research activities or even for farming of both, then the units of this is 50. So till to the extent of 50 units, the sugar factory who is using this land for the farming and who is using this land for the purpose of research activities can use the land to the extent, can hold the land to the extent of 50 units. So this is one criteria. And any person who is cultivating the land as a plantation crop, or if that is being decided as a plantation crop in other land, then that will be determined into the taking into all those consideration, like what shall be the value of that plantation, what is the units that they can use in. On the basis of that, they can go for the ceiling limit or calculate the ceiling limit. So this is how we see upon the limitation is been fixed. And of course, in Karnataka, if you look, 1 unit is equal to 5.4 acres of land. 1 unit is equal to, I repeat, 5.4 acres of land. So to the extent of these units, because wherever you read under the land reforms, it speaks, especially in the Karnataka land reforms, it speaks upon that. And that is, you can hold the land, and when we go calculating with the ceiling, we say that ceiling is described in the form of units. And if you go in dividing this, it is 1 unit is equal to 5.4 acres of land. You can go on using it. And it goes further. It says, that is section 64 of the Acts provides saying this: where on account of any such transfer or gift or purchase or exchange or mortgage, etc., 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 by surrender, bequest, or whatever, inheritance, partition, whatever it is, if a person acquires a land, a surplus land, which is being made, that is to that of a ceiling limit, to the extent of ceiling limit, he can get with. But anything above this, that is, if he owns a land that is surplus land, then such land should be surrendered to the state government, that is whatever the excess land that is holding with. In a way, I can say section 65 also says that whatever the surplus land, after having calculating, that is after the act was brought into force, if you happen to hold a surplus land in your name, then that land what is left in surplus to that of the ceiling limit, that is both section 63 and 64, shall become the property of the state government, and you are required to surrender it to the state government. In fact, the Amendment Act of 1974, inserting capital A to section 65, that is 65 capital A, it laid down certain lands are deemed to be in the excess of the ceiling area. That is, where as a result of irrigation of any land which is a source through which the water has been provided or source is been constructed by the state government for any land for the purpose of irrigation, together with any member of the family which exceeds the ceiling area, then that shall also be considered to be deemed to be as a land which is in excess of the ceiling limit and the land vest with the state government. It is something like this. In Kannada, we used to call it as Gomala lands. That is, where the state government has allowed you for grazing. If that is also a land which is uniting with, usually while calculating, we give out the Gomala land to be considered with. But still, if that is the land, and where if you are using the land which has been constructed by the state government, and any land held by a person along with the family members together or the members of the family, then that should also be considered to be as a ceiling. That is, it would be considered for calculating the ceiling limit of the person. So once when any person crosses this ceiling limit, that is ceiling area, whether it is 10 units or 20 units or 40 units or 50 units, whatever it is, when they cross the ceiling limit, they are at the duty to file a declaration of holding. That is, after the Amendment Act of 1974, it said that is a person who happens to hold a 10 acre of land, which is of an irrigated land, and where that irrigated land is used for an irrigation with the source of water provided by the state government, Or it says, where if the 20 acres of land, wherein if that on that land if paddy crops are green grown with the help of rainwater, or where if it is a 40 acres of land which is classified as a dry land having any irrigation facility with the source of the water of the state government, then such persons are compulsorily required to declare themselves as before 31st day of December 1974. Then I repeat, that is, as of the 31st day of December 1974, we shall see that the declaration has to be made by the person. And the other areas, every person who happens to have acquired an excess land to the extent as that has been specified under section 63 and 64 and 65, my friends, we shall say that is 63 and 64 more particularly, then those shall also be given to or specified to the extent of land what they are holding with. This is the second criteria. And also it says, that is, they have to make a declaration as to the amount of units of land that what they are holding with. So also it says, every person who happens to hold a land which is deemed to be an excess land of the ceiling area under section 65, that is surrendering of land which it calls to the state government, then such person shall in a prescribed period furnish the declaration before the Tahsildar within the jurisdiction of where the land is situated with stating all those contents, like the particulars, like what is the particulars of land, what kind of land it is using with, that is particulars of land, particulars of the members of the family, and also such other particulars as that is being prescribed by the concerned authority, that they have to supply with all these things, given information with respect to all these things. And if a person happens to hold a different categories of land, because under land reforms we have category A, B, C, D. We have 4 categories of land, that is class A, class B, class C and class D lands. We have these classes of land. So if a person happens to hold a different categories of land, then that shall be determined by converting all those categories into any one category, and the formula would be applied therein in ascertaining the ceiling area. Suppose let me say my land is an A category land. Then the A category, that is 1 acre of A category land, shall be calculated accordingly with the 2 acres. Suppose there is category A land and category B land. So category 1 land comes with 1 limit, 1 unit, and another category comes with the another unit. Suppose this I can hold 1 unit is considered equally to that of the 2 units of the land which is big. Now I will apply the formula in that. That's how we would say 1 acre land is in the category of 1, 2 acres of land in the category 3, and 4 acres of the land in category 3, that is D class land we go with. So A class land, B and C class land are called as 1 category, and D class land are called as 1 category. So on the basis of this formula, we shall see that the same is applied with in ascertaining the ceiling area of a person. So when such a ceiling area is exceeded, basing on all those category, or when an application has been made to this, that is on the ceiling area that is being made, then the Tahsildar shall have a power by giving a notice requiring upon a person to reason to believe that who happens to hold the land or who is in residence or who furnishes for a declaration, calls him furnished to declare that the amount of land that what is been holding by him within the prescribed time after having given the notice. That is, it should not be more than 30 days of time. So within this 30 days, any time after this 30 days also you can give, calling him to file a declaration or furnish a declaration with respect to the land holding what is. And this declaration shall be made, as I was then saying you, it is under form 7, 1374 now I was speaking to. So it should be on the same thing, and the person who was holding a land on or after, that is 18th November 1961, before the commencement of the Amendment Act of 1974, any of these things, my friends, that is 10 acres, 20 acres, 40 acres of land we see, shall make a declaration, and that declaration shall be made within 180 days, that is as from the 11th September 1975. So they have to compulsorily make a declaration in the form and show what is the amount of land that they are holding. Once when they make a declaration, the Tahsildar would look upon, that is, when I make a declaration, it says that declaration shall be made with the concerned jurisdictional Tahsildar. Suppose if it is a case where my property comes within the jurisdiction of 2 or more Tahsil areas, then to whichever the part, greater part, that is where my property rests with, or territorial region rests with the greater part of one Tahsil, I have to make my declaration in that Tahsildar with all those particulars, as I again say, particulars of the land, particulars of the family members, particulars of the land that I am holding, the land that is being transferred, that is any manner in and after, that is before 24th January 1971. In any of these things, they can go and make, that is, if I have transferred the land, even with those transferred land, I have to make my declaration. And I should also make my declaration to the effect that the particulars of a person who have been the land to whom the transfer is being made. So all these things is being made, and the provisions of this mutatis mutandis applicable to all those declarations what is being furnished there. So in this form, we shall see that the declaration has to be made by the person, where even after the notice of declaration is being sought, if the person fails to make a declaration, then under section 66 capital A, penalty for the failure to furnish a declaration can be imposed with. Now, as required under section 66, you are required to file a declaration. Failure to furnish a declaration, then the concerned Tahsildar may cause you to show as why you have failed to give a declaration, that is with a reasonable cause. He may ask him to file a notice. That is, he may ask you to furnish a declaration, having knowing the reason that what was the reason behind of you not filing this declaration. Or in a way, I can say that is, even after the notice is served upon to the person, without any reasonable cause of him, if a person has failed to give a declaration within the specified time as that is specified by the Tahsildar, or where if the declaration has been furnished by a person is said to be a false declaration given by him. If it is a false declaration, or knowingly it is a false, or believing it to be false, still he makes a declaration, then the Tahsildar shall have a power to show cause him as within 15 days from the day of such notice as why the declaration is not been properly filed, or to furnish a proper declaration. And in this regard, he may also extend a penalty imposed against the person to an extent of 500 rupees. Even of this, if there is no reply has been filed before the Tahsildar, or to the satisfaction of what Tahsildar has sought with, if the same is not being filed, and without any reasonable cause, if they have failed to furnish the declaration, then they can be again imposed with the penalty as that is been appropriately found by the Tahsildar as to that of the false information. And he may also call for filing a correct information or file a correct particulars within 1 month of time of what the declaration has been fails to, that is, if any person, in spite of all these efforts, if they have failed to comply with the requirement as what Tahsildar has sought upon with, that is with respect to the title or with respect to the interest of any person in that of the land, or to the extent of the land in his, which is holding, or the excess of the land which is holding, then a part of the penalty, my friends, we can also see that there can be, that is, the land can be forfeited, and the state government shall thereupon make upon that land that, and it vests with the state government of the land which is been forfeited with. So this is how, my friends, we shall see what shall be the ceiling limit in respect of the land what they are using with. This is how we can go with as to the ceiling of land area. That is, we can say ceiling is more particularly, that is, it speaks that in generally I am speaking, that is, what is the maximum extent of land that you can hold as an individual, as a family, as a joint family, as a trust, as a research center, educational institution, charitable institution, religious institution. It has a ceiling limit on all these areas. So this is about the ceiling, and the question would be, one question would be compulsorily asked on this. Be ready on this area. So this is one. The next comes as the surrender of land. Surrender of land. Section 67 to 73. Surrender of land. 67 to 73 speaks on this surrender of land. It lays down several provisions with respect to the surrender of land. There it says, provided with the section, and that is under section 66A, or on the receipt of the declaration made before the Tahsildar, then the Tahsildar in fact shall verify all those particulars with respect to the contents that is being furnished by the person, with all respect to that of the survey number and to the extent of the land what a person is holding. He shall also determine whether the land is a land which belongs to A class or B class or C class or D class land, because that is the ratio of they are going to calculate with. So that would be determined, and after having determined with, if the Tahsildar is satisfied, that is before it is situated, that is in the jurisdiction where you have been filed with. If the Tahsildar has a doubt with this, that is, say under AA of this 67, it says, if the property is situated in 2 or more regional Tahsildars, that is 2 or more areas, what we understood is, wherever the greater part of the land is situated in such jurisdictional area, I have to file my declaration. But if the Tahsildar, after having verifying all these things, that is after having looking down to a declaration of your land holding, and if he finds that there is such portion of the land which is undeclared by you, or if the declaration has not been properly made, then in such case the Tahsildar, after having making a report of him, send such copy of to the concerned Tahsildar, that is the remaining portion of the property where of a person is situated, send a copy of this declaration, a letter in this regard, who shall also make a verification and determine the portion of the land that what a person is holding. That is, after having decided with this, a copy of that declaration in this connection too shall be again resent to the former Tahsildar, which the Tahsildar shall place this before the tribunal. So this is one way of having ascertaining as how the land is going to be looked upon with. And thereupon, of course, when it is being taken before the tribunal, that is, if there is any, what I can say is that if the ceiling cannot be properly ascertained with, then on the enquiry so being made, the tribunal shall have a power to determine the extent of a person who is holding the land. That is, whether the person is holding the exceeding the ceiling area or whether it is the ceiling area. And where if the tribunal is satisfied, like, or where it is found that the person holding a land is less than that of the ceiling area, then it may allow a person or entitle a person to retain that land what is holding with. But where if it is found that is happening to hold more than that of the ceiling area, then it may call upon such person to surrender that land of which is said to have been held by him in excess to that of the ceiling limit. And the orders of the tribunal in this regard is final. The same shall be communicated to a person through the concerned Tahsildar with respect to the decision of the tribunal. And my friends, here also one hay has been included, that is, where a family consists, where the land in which they are holding is to the family, and the family consists of the even a Stridhana property land, then the surrender may be to the extent of that of the Stridhana land which they are holding with, and it shall not be more than the proportion of the Stridhana land what they are holding with. So subject to this, my friends, we can see that the land has to be with surrender. And where if the land is being personally cultivated by a person and the surplus land has been given to the tenants as it has been surrendered out with, then the same land can be cultivated by that is, if they are cultivating the land, they can take upon those land and they can hold it for personally. Or I can say you in this way, where a person holds a land cultivated by him personally as well as the land cultivated by the tenant, then whatever the surplus land that is there in his part shall be with reference to the land cultivated by the tenant can be given to that as by way of surrender. This is one another criteria. Or it says that if anything is not being made of this, the tribunal shall cause a notice or serve a notice upon the person specifying the extent of the land which it is being required with, and to file a correct statement within the period that is being prescribed by the person for so far as the surrender is concerned. So on such calling of a person to specify the surrender, person who is willing to file a declaration may also go in this regard for a private surrender. Suppose say if I have given it to the tenant, I say that I don't want this, I'll be using my that because it is above the ceiling limit. So where any person who fails for such declaration within the prescribed period of what the tribunal has been given to, or proceeding for approving of surrender, then the land which is not being surrendered shall deemed to be said or understood as it is surrendered by such person. So the land so surrendered, if it is not suitable for a person to have an accessibility, that is while surrendering or anything. Suppose say I am using three varieties of land in three different places within the same subdivision. Now the land what I am using may not be suitable for the reason that I have no transport facility, where I have no accessibility to that of the land. In such cases, I can choose any one of this. Even though it is under the tenant, I can choose any one of this land and I can take my right over that land, and that is on the other part I can surrender of the land. So in such cases, the tribunal can accept that and it can consider for such surrender also. Or also in such cases, the tribunal can call for a fresh statement by that of the person. So on filing this such statement or any part before the tribunal, and with the approval of the tribunal thereupon with respect to the surrender of the portion, then the surrender could be accepted by the tribunal. But where if a person fails to file a fresh statement when called by the tribunal, then the tribunal itself has a power to select any one of the place for you and ask for the remaining portion to be surrendered with. So this is one area we see. Or in other cases where there is a failure to file a statement within the prescribed period of what the tribunal has called upon you to surrender the land, then in such case, my friends, that is to the effect thereupon, the land whatever that is held to be in excess shall deem to be as surrendered by such person. That is, it says that is in order relating to this of surrender can be made upon with, passed in this respect, and as to the survey number, subdivision, everything can be made, and thereafter the tribunal can say this is the land what is going to be surrendered with. So this is how we see surrender goes with. And of course section 67 capital A says every person who is possessing a land in excess of the ceiling area or determined with that of the ceiling limit as concerned, then or what the state government have determined in this, and still is in the possession of the property to the extent of the land, then such person should have been surrendered, and whatever the compensation that is being payable on this, on the use and occupation of that land, shall be also be determined by the tribunal, because thereafter the land vests with the state government. So this is how, my friends, how surrender takes place. And once when the surrender, vesting of land surrender takes place, the land becomes to the owner. See, there is also a surrender by a limited owners. See, not only by the owner of the property, by the landlord of the property, the surrender can also take place by the limited owner, section 69 says. See, if the surrender has been given by the limited owner over the property, then the property of which he has surrendered with shall go to the reversioner. It is not to the state government. It goes to the reversioner. And once when it goes to the reversioner, then within 90 days of what a person gets the property as a reversioner right in the property, within 90 days of time he has to make a declaration before the Tahsildar. So if that declaration, if it is not exceeding the ceiling limit, then he is entitled to hold. But if it is exceeding the ceiling limit, then the same shall vest with that of the state government. And the reversioner to whom the land vests in is also liable to pay to the limited owner that is the annual amount of equivalent to 4.5% of the amount payable to the owner in respect of the land which is vesting in and continue to be in the possession of the reversioner. This is in case of the limited owner surrendering the property. Likewise, there can also be a surrender by an usufructory mortgage, where if a surrender is being made by an usufructory mortgage, then the possession of that property reverts in every case to that of the mortgager himself. And the mortgager now has to undertake the same criteria, that he has to look in that whether it is the property which is getting in addition of this would be exceeding the ceiling limit or not. And if it is not exceeding, then is entitled to, but if it is exceeding, then it should surrender the land according to that of the provision of section 67. And to the mortgagee whom the possession is been reverted shall be liable to pay the mortgage money which is due on that of the usufructory mortgage and respect of the land as a security for the payment what is been made. Where the possession of the land is being surrendered by such mortgagee who does not revert back to the mortgager, then the state government shall have a power over the land, and all those properties shall become the property in the encumbrances, and it would be to the state government, and all those encumbrances stands in the form which would be free from all those encumbrances, and the title stands in the favor of the state government. This is one way. Likewise, we also see it is a case of surrender of land by the tenant, where the land is surrendered by the tenant. The possession of the land shall restore back to the owner in every case, we see, to the extent of what this owner himself is holding the property. Again, the same thing, which is not going above than the ceiling limit. So the owner to whom the possession of land reverts with shall be liable to pay upon the compensation equal to 1 year of the income of such land, and the possession of such surrender by the tenant does not, if it does not revert back to the owner, then the state government may take the land for publication of the land as it shall be. So in this way, my friends, we shall see that the surrender of the land can be made, and the amount payable on the surrender of the vesting of the land by to the state government is as determined by the state government. I was then saying you, that is where if it is 25,000, then 25,000 into 15 times, where it is more than 25,000, 5,000, it is more than 12 times, and it is into 12 times, or where the balance it is 10 times of that money. So in this way, my friends, the value is also being considered, where if it is a D class of land, 20 times is to be paid. So this amount is being payable at the annual rate of whatever that is being assessed with. So in this form, my friends, we shall see that the surrender can be made, and there is also, my friends, there is a prohibition of alienation of certain land. That is, any person who happens to hold an excess land which is not alienating, that is if he has received the property by way of sale, gift or exchange, until it is furnished with the declaration under section 66, that if a person happens to hold a land, then we say that it is above the ceiling limit. But by virtue of this, if any person alienates the property by way of sale, gift or exchange in whatever the mode it is, such sale, exchange, whatever the alienation he makes in should be, that is the transfer or alienation becomes null and void. However, this is only to the extent of the surrender as the case may be. That is only to the extent of surrender what is required to be made. If he has transferred the property, only to that extent it becomes null and void, where if it is not exceeding the ceiling limit, then the same cannot be acquired with. However, we say that if there is any change in the classification, or if there is any consequential improvement that is being made by the members of the family or himself, he is entitled to claim for that. This is one area. Likewise, under section 77, it also speaks with the disposal of surplus land, where the land vesting in the state government is subject to the reservation, that is which you say reservation, which by the Amendment Act of 1992, which gives saying that is 75% of the land can be held upon with. Thereafter, it says that the grant first, that is whatever the land that is being received by the state government shall be disposed, and 75% of the land, whatever that is there, shall be subject to the restriction that it will be given to SC, ST. And in this behalf, the DC shall have an authority to decide upon what shall be the land, what is the dispossessed tenant, displaced tenant, and landless agricultural labor. All these things would be decided by that of the DC, and the land shall be given to that of the landless person, or to that of the person who is residing in the same village or locality or panchayat, or to an agricultural labor who is employed in that of the agriculture, and provided where the income of that person does not exceed more than 20,000 rupees. Or it shall also include a person who is a released bonded laborer. So all these persons are entitled to have a right over the property. That is, the state government and acquiring of this land, surplus land, can be redistributed to these persons. So also, if any tenant is being dispossessed by the act of death, that is, by any owner of the property who is cultivating the land personally, then this dispossessed tenant can also be given with the cultivation of those land. But only thing is that this dispossessed tenant should prove it that is, he was being dispossessed between 10th September 1957 to 24th January 1971. If we can establish with this, then we can say such dispossessed tenant can also be given with the right. Likewise, we shall see there is also a displaced tenant. That is, person who is being deprived with an agricultural land, which he was a tenant, and by virtue of acquisition of the land, or because by virtue of resumption of the land by the soldier or seaman, if he has lost the personal cultivation on that of the land, then he can also make an application for that of the land which it has been surrendered with. Or where the land has been reserved for the person belonging to SC and ST, and in such case those lands shall be also be granted accordingly, with a saying that it should not be disposed of for the period of more than 15 years. There is no such alienation or no such interest shall be created in respect of the same. So this is how we see. So the DC is also an officer who has been authorized, that is, while granting the land, and he shall, after having granting the land, he shall forward it to the sub-register, which I have already also spoken to you when I was discussing to you with the land revenue. The same thing, the DC is authorized person who would be looking into the granting of land, forwarded the same to the sub-register, and the state government shall also consider that for granting of the land in cases of public interest. So this is how, my friends, we can see that how the lands are going to be declared, and how the surrender of land is going to be moved, or how surrender is going to be made, and what would be the effect of this surrender, or what would be the outcome of this surrender. So these are the issues which I wanted to speak in today's video discussion. And I can say that what all the discussion I had, including surrender of land today, that is in this video, I can expect 2 questions. You can expect 2 questions for the examination, whether it is in the form of short notes or whether it is in the form of main question. You can expect this from this part of the